Chapter 18, Holder in Due Course, presented by Kelly Herzik. In this lesson, we will be covering Holder in Due Course Doctrine, Requirements for Holder in Due Course Status, the Shelter Principle and Holder in Due Course, Signature Liability, Warranty Liability, and Avoiding Liability for Negotiable Instruments. First, we will discuss the Holder in Due Course Doctrine. A holder in due course, an HDC, is a holder with special rights and protections who acquires a negotiable instrument in good faith. A holder of an instrument is subject to the claims and defenses of a negotiable instrument, such as breach of contract. That's a plain holder. However, in contrast, a holder in due course has higher protections and generally takes free and clear of any personal defenses to the instrument. We'll discuss what a personal defense is later in the lesson. There are 4 requirements for holder in due course status under UCC 3-302, and all of them must be met for someone to be able to have the protections of holder in due course status. They are: the party must be a holder of a complete and authentic negotiable instrument. The holder must take the instrument for value. The holder must take the instrument in good faith. And the holder must take the instrument without notice of any defects. For example, ABC Painting buys painting equipment and signs a note to the seller, Equipment Inc., and that's for $10,000. Equipment is a holder of the note. If Equipment transfers the note to its business landlord, Larry Smith, to pay rent, Smith can be a holder in due course of the note signed by ABC Painting if he takes the complete and authentic instrument for value, in good faith, and without notice of any defects in the note. Assuming the note is original and properly endorsed from Equipment to Smith, who has no notice of any problems or defects with the note, and who gives value in the form of rental credit, and in good faith, he is a holder in due course. Now, if ABC Painting later finds out that the painting equipment is faulty, he can sue Equipment for breach of contract, but he must still pay Smith under the $10,000 note because Smith is a holder in due course and takes free and clear of ABC Painting's breach of contract defense. In contrast, if Equipment had not sold the note because providing defective painting equipment would be a material breach, ABC's Painting's performance under the contract would be discharged, meaning their obligation to pay under the note would be ended. So you can see the big protections that holder in due course status has. We will begin with the first element of holder in due course status, a holder of a complete and authentic negotiable instrument. To be a holder in due course, the first step is to be a holder of a negotiable instrument. Remember, we've discussed what a negotiable instrument is in Chapter 17. A holder, a plain holder, is someone who is in possession of an order instrument payable to him or in possession of a bearer instrument. Remember, bearer paper is usually blank or paid to cash. If a person has possession of an order instrument payable to another person, he is not a holder. He is just a possessor. A thief who steals an order instrument is not a holder and can never be a holder in due course. However, if a thief steals bearer paper, even a thief is a holder and can present it for payment. That is the only time a thief can be a holder, is if they are holding bearer paper. Remember, the instrument must be negotiable for holder in due course status to apply. The negotiable instrument must be complete and authentic. A holder can complete an instrument like a check as long as the completion is consistent with the intent of the issuer. For example, filling in the date on a check that is accidentally left blank would be consistent with the holder's intent. However, if a holder completes an incomplete instrument that is inconsistent with the intent of the issuer, then the instrument is considered materially altered. If an instrument has clearly been materially altered on its face, or is obviously irregular or incomplete, then its authenticity is in question. If someone takes an instrument in this state, then they are not taking as a holder in due course. I represented a bank client that bought a large batch of mortgages and notes. In these huge bulk sales, individual paper is not scrutinized for errors. They take them as a batch. Some of the notes, which are negotiable instruments generally, had clearly been altered on their face by substituting in pages that were different to raise the interest rates. It turned out to be a fraud scheme by a loan closer who went to jail. However, my client did not have the protections of holder in due course status in the lawsuits filed by the borrowers and was subject to all the defenses raised by those borrowers. As a result, my client lost a lot of money and had bad paper they couldn't enforce. They could sue the original lender, but it was bankrupt, so my client took the loss. In contrast, if my client had been a holder in due course, then they probably could have enforced the notes against the borrower, at least as to the original interest rate that the borrowers originally intended. But without that holder in due course status, they lost everything on the notes. The next element of holder in due course status is taking an instrument for value. In most areas of the law, taking something for value means taking something for consideration. However, under the UCC, the for value requirement is more stringent than consideration under the common law. Under the UCC, the party must take the instrument in exchange for a promise that has already been performed. The UCC expressly excludes from for value any promise that has not been performed. The party seeking holder in due course status must suffer an out-of-pocket loss under the UCC Section 3-303. If the party receives the instrument as a gift or through mistake, he is only a holder and not a holder in due course. A holder can take an instrument for value if he performs the promise for which the instrument is issued, acquires a security interest or some other lien in the instrument, takes the instrument for payment of a preceding claim, or exchange the instrument for another negotiable instrument, or exchanges the instrument for an irrevocable obligation of a third party. Now you may be wondering why for value excludes any future promises under the UCC. The purpose of holder in due course status is to protect financial intermediaries. Someone who takes an instrument as payment or processes a payment should not be required to shoulder the risks of a transaction. It incentivizes them to engage in financial transactions and keep commerce moving. If a party has not yet performed the promise, the party has not completely committed to the financial transaction and therefore should not receive the special legal protection that holder in due course status provides. The next requirement for holder in due course status is to take an instrument in good faith. The UCC defines good faith as honesty in fact and the observance of reasonable commercial standards of fair dealing. To act in good faith, a holder cannot deviate from reasonable commercial standards of fair dealing, but must still act honestly. This standard contains both elements of objective standards and subjective standards, so it's a blend under the UCC. Some states lean towards objective standards under the common law and others lead toward subjective standards under the common law. The UCC is a blend of both. An objective standard focuses on the reasonableness of the holder's actions compared to the reasonable or ordinary course of conduct in business. A subjective standard focuses on the holder's individual behavior, whether the holder acted with honesty in fact. So you can see that blend. The last element of holder in due course status is taking an instrument without notice. A holder must take an instrument without notice of any defects in or defenses to the instrument. For example, material alteration is a defect in the instrument itself, while breach of contract is a defense to the instrument's enforcement. If a person is a holder who wants holder in due course status, they must take the instrument without knowledge of either of these types of defects or defenses. If a holder has notice of any of the following, the holder cannot be a holder in due course. The instrument is overdue, the instrument has been dishonored, the instrument was issued as part of a series that is in default, the instrument has been altered or contains an unauthorized signature, there is a claim to the instrument, or another party has a defense or claim in recoupment to the instrument. Any of these will destroy holder in due course status. Now, to have notice of a defect or defense means the holder has actual knowledge of it, receives notice of it, or the facts and circumstances give the holder reason to know of it. This is a know or should have known type of standard. Next, we're going to discuss some problems with notice. Whether an instrument is overdue depends on the type of instrument it is, whether it is a demand instrument or a time instrument. A demand instrument is one payable on demand, meaning as soon as it's presented, and becomes overdue if it has been outstanding for an unreasonably long period of time after its date. For checks under the UCC, it becomes overdue 90 days after its date. For example, if a check is dated January 1st, 2020, and someone seeks to negotiate it to a third party on June 1st, 2020, on its face, the check is overdue. If someone still takes the check as payment, they do so at their own risk because they would not be a holder in due course, only a holder. A time instrument is one that is payable at a certain time, and it becomes overdue any time after the specific due date on the instrument. If an instrument is payable in one lump sum, it is much easier to see that it's overdue when the lump sum is not paid by the due date. However, installment contracts are one where payments are due in a series of payments, like a mortgage and its accompanying note payable monthly. If a party misses a payment on the principal, it is overdue until the installment is paid. But if the payment missed is only for interest, the instrument is not overdue. So how do you figure that out? Well, parties typically use credit reports to see if any installments on principal are overdue. Credit reports are prevalent in lending, and if a bank is considering buying a note from a retailer, checking the credit report for overdue payments is standard, and it would be considered commercially reasonable to review a credit report prior to buying. Now remember my client who bought notes in a large sum. That doesn't work if it's a huge bulk, if it's thousands of mortgages. But if it's just one, looking at the credit report would be commercially reasonable. Now, if there are missed principal payments on the report, the bank would have notice of the note being overdue, and if they still bought it, they wouldn't be a holder in due course. If they failed to check the report, notice could still be imputed to the bank because given the circumstances, the bank should have checked the credit report and should have known that there were overdue payments. That's really what happened to my bank client. It's just that it wasn't practical to check the notes, to check the credit reports on thousands of notes. Another problem that would destroy holder in due course status is taking an instrument that has been dishonored. If a holder takes an instrument they know is dishonored, the party cannot be a holder in due course. An instrument is dishonored when a party refuses to pay the instrument despite it being presented for payment in a timely and proper manner. If a holder has no reason to know that an instrument has been dishonored, the party can still become a holder in due course. If a party is aware of any claim or defense to an instrument, that party has notice and cannot become a holder in due course. But if he has no reason to know of any claims or defenses, even if they exist, then the party can become a holder in due course. Holder in due course status does not apply to all defenses to an instrument, just personal defenses. Personal defenses are defenses applicable to the underlying agreement or between the original parties to the underlying agreement, such as breach of contract. It deals with the actual transaction itself. Real defenses apply to any holder, including a holder in due course. You can see the differences between real and personal defenses in Exhibit 18.3 of your textbook, and that's a good short summary of what the differences between the defenses are. But real defenses, like fraud, attach to the instrument and cannot be stripped out by transferring the interest to a holder in due course. In other words, real defenses are a justification for a maker or a drawer not to honor a negotiable instrument, even if it has been transferred to a holder in due course. Next, we're going to discuss something called the Shelter Principle and holder in due course status. The Shelter Principle is the idea that when an item is transferred, the transferee receives all the rights the transferor has to the item. Under the Shelter Principle, if a holder cannot attain holder in due course status because of some defect, as long as a prior party in the assignment chain was a holder in due course, then all the subsequent holders have the rights of a holder in due course. The party trying to use the shelter principle to attain holder in due course status does not have to take the instrument directly from a holder in due course. It only requires that a prior holder in the chain was a holder in due course. There is an exception for fraud and illegal acts. If a party engages in any illegal act with respect to the instrument, then the party cannot become a holder in due course, even if they obtain the instrument later from a holder in due course. You may think this is unfair, but it's the goal of the UCC, and the shelter principle encourages the marketability of negotiable instrument, which is one of the major goals of the UCC. Next, we're going to discuss signature liability. It's not always clear who should bear the responsibility for the amount of a negotiable instrument, who has to pay. The first concept of liability is signature liability, which is liability due to the party's or the party's agent's signature on the instrument. If you sign the instrument, you can be liable to pay it. If a party does not sign the instrument, they cannot be liable for it. That is a pretty cut and dried rule of law. For example, if a husband and wife enter into a mortgage to buy a home, but the bank relies only on the husband's credit, then the husband may be the only signatory on the accompanying note, which is a negotiable instrument. The wife who does not sign the note is not liable on the note. She may sign the mortgage because of community property or inheritance rights, but she won't be liable on the note itself. So she doesn't personally have to pay it back, only the husband does. Next, we're going to discuss primary liability of makers and acceptors of instruments. A party that is primarily liable on the instrument must pay the stated amount on the instrument when it is presented for payment. This type of liability attaches as soon as the instrument is issued. A maker of a negotiable instrument is primarily liable for it. For example, a maker is a person who is promised to pay a set sum of money to the holder of a promissory note, or a bank that has issued a certificate of deposit. Now, a maker who signs and issues an instrument is also primarily liable. For example, a bank that issues a cashier's check is primarily liable for the amount of the check as soon as it is issued, because the bank both issues and signs the instrument. An acceptor is a drawee of a draft who accepts and signs the draft. And an acceptor agrees to pay the draft when it is presented and is primarily liable. Drawees or acceptors, particularly with respect to checks, are always banks, and drawees are usually banks. They're usually not third parties. A party that accepts a draft by signing on the face of the draft is also primarily liable, such as a bank that accepts a check is primarily liable for the amount of the check. Now we'll discuss secondary liability of drawers and endorsers. A party that is secondarily liable for a negotiable instrument must pay the amount of the instrument if the primary party defaults. Drawers and endorsers are secondarily liable on instruments. Drawers are parties that write an order or the person who writes a check. Endorsers are parties who issue an endorsement on an instrument to negotiate it, restrict its payment, or incur liability. A lot of times they are the original payee, but they could be a payee that is down the line. 3 conditions must be met for a drawer or endorser to be liable on an instrument. The holder of an instrument must present it in proper and timely manner. The instrument must be dishonored, and notice of dishonor must be given to the drawer. For example, if Bob writes a check from his checking account to Cox Cable to pay his cable bill, Bob is the drawer of the check. Bob's bank is the drawee. Cox Cable would be the holder of the check. Cox presents it to the bank as the drawee to pay the check amount. If Bob does not have enough money in his account, the bank does not generally have to pay the item, of course, absent overdraft protection agreements with customers. If the bank does not pay Cox due to insufficient funds, the bank is said to have dishonored the instrument. Bob, as the drawer of the check, is only liable for it once the check has been dishonored and notice is given to Bob of the check's dishonor. Presentment is the act of making demand for the maker of a note or drawee of a draft like a check to pay the item. Remember, the drawee of a check is the bank. An instrument must be presented to the proper party in a timely manner and in a proper way, depending on the instrument and its requirements. You can see Exhibit 18-4, and it gives a good summary of how a note or draft must be presented. If the instrument is timely presented in a proper manner, but the drawee, the bank, explicitly refuses to pay it, the item is considered dishonored. That's a term of art. Refusal to pay an item because of situations such as improper proof of identification or signature endorsement issues does not dishonor the item. Those could be cured and the item paid. If the party is a bank, they are the drawee. The bank has 1 day to give notice. The bank must give notice before midnight of the following day after it dishonors an instrument. Other parties who are not banks have 30 days to give notice. Notice to secondarily liable parties can be given in any commercially reasonable manner, oral, written, or electronic form. The item must be explicitly identified and the notice must state that the item has been dishonored. It can also be stamped dishonored directly on the draft or the check. Next, we're going to discuss accommodation parties. An accommodation party is a party who signs the instrument to provide credit for another party who has also signed the instrument. Accommodation parties can be primarily or secondarily liable on the instrument depending on their role in the transaction and how they sign the instrument. They can sign as makers, drawers, acceptors, or endorsers, though they are most often makers or endorsers. Most often they are considered a surety for the other party and can also be referred to as a guarantor, third-party guarantor, accommodation maker on a promissory note, or a cosigner. As a maker, an accommodating party has primary liability on the instrument, such as a cosigner on a loan, but has secondary liability when signing as an endorser, such as a parent company that provides accommodation endorsements to a subsidiary as a guarantor. If the other party fails to pay, the holder of the instrument can look to the accommodating party for payment. Now, suppose you want to buy a new car, but because you're a college student with not much work history, the bank making the car loan requires a cosigner on the loan, such as one of your parents. Both you and your parent must sign the note and are both considered borrowers and makers, making both of you primarily liable on the car loan. If you stop making payments, the bank can sue either or both of you for payment. A surety or guarantor, in contrast, only endorses the note. If the borrower on the note defaults and cannot pay, the bank can seek payment from the surety who is secondarily liable. Now, if the surety pays the debt for the party that defaulted, they can then try to seek restitution from that party. Next, we're going to discuss unauthorized signatures and endorsements. Generally, if the signature to a negotiable instrument is unauthorized, the signature will not impose liability on the named party. This generally applies in forgery cases and unauthorized agent situations. In forgery cases, if a party forges a signature of a party and then does not pay, the innocent party whose signature was forged is not liable on the instrument. If an agent does not have actual or apparent authority to sign on behalf of a principal, the principal is generally not liable on the instrument, though the agent will be. The principal can ratify the signature after the fact and honor the signature, making the principal liable on the instrument and releasing the agent's liability. That's ratification after the fact. There are exceptions to the general rule of non-liability for an unauthorized signature, most notably due to negligence, the imposter rule, and the fictitious payee rule. So let's talk about the exceptions to liability for unauthorized signatures that I just mentioned. The first one, of course, is negligence. In some instances, a party's own negligence does not permit the party to escape liability for an unauthorized signature. If the party substantially contributed to the circumstances making it possible for a forged signature, that party may not escape liability. Example, leaving a signature stamp laying around without locking it up or securing it appropriately. If someone steals the stamps and uses it, you may still be on the hook even though you didn't authorize their use of the stamp due to your negligence in leaving it laying around. Then there is the imposter rule. This is a rule that holds that if one obtains a negotiable instrument by impersonating another, and then you endorse it with the impersonated party's signature, the loss falls on the drawer of the instrument, the person who issued it. If a maker or drawer issues an instrument like a check to an imposter, the imposter's endorsement will be effective, meaning the drawer is on the hook for the loss because the maker drawer was in the best position to determine if he or she was being duped. Then there is the fictitious payee rule. If a payee does not exist, is fictitious, and a party endorses the item with a fake payee's name, the maker-drawer of the instrument will be liable on the instrument since the signatures are not treated as a forgery. That is a very big scam. I have seen it before. One of my criminal defense clients actually was very good at this. He had a whole bunch of payees that he was getting fake checks, fake payroll checks for, and the only reason he got caught is because he went on vacation and one of the checks was issued and someone tried to figure out where the check went, and then the whole scheme kind of unraveled. Now that we've discussed signature liability, we'll turn our attention to warranty liability. The second concept of liability is warranty liability, which is liability due to the party's transfer of an instrument that breaches a warranty associated with the instrument. Now, there are two types of warranty liability: transfer warranties and presentment warranties. A transfer warranty is a warranty created by a party who transfers a negotiable instrument. A party who transfers a negotiable instrument to another party in good faith for consideration creates transfer warranties regarding the instrument and the transfer itself. Now, transfer warranties always apply to the party to whom the instrument is transferred, the transferee, whoever accepts the instrument. If the transfer is through endorsement, signature on the back, transfer warranties apply to any future holders. If the transfer does not occur through endorsement, the transfer warranties apply only to the transferee. Well, what warranties are created under a transfer warranty? When a party transfers a negotiable instrument for consideration, the party warrants that the transferor is entitled to enforce the negotiable instrument, that signatures on the instruments are authentic and authorized, the instrument has not been altered, the instrument is not subject to a defense or claim in recoupment, and the transferor has no knowledge of insolvency proceedings against the maker, acceptor, or drawer of the instrument. That means none of those parties are in bankruptcy. If the warranty is applied and there is a breach of a warranty, the parties entitled to the warranty can bring suit against the transferor, the warrantor, for any damages resulting from the breach. The transferee can bring suit against the transferor as soon as a breach is discovered, but must give notice to the transferor within 30 days of discovering the breach. If the transferee does not give the 30-day notice to the transferor, the warranty can be discharged to some extent. It depends on the circumstances. However, if the instrument is a check, the warranties cannot be disclaimed. Other instruments, such as notes, can have warranties disclaimed using such language as "without warranties" in the endorsement. Then there is the presentment warranty. Remember, presentment occurs when a party properly presents an instrument for acceptance or payment, and the party to whom it was presented accepts the instrument or pays it in good faith. Now, a presentment warranty is a warranty covering the parties accepting an instrument for payment that is created to ensure that the accepting or paying party is paying the proper party. Both the party presenting the instrument and any previous transferor of the instrument make presentment warranties. If there is a breach of the presentment warranty, the acceptor can recover from the transferor and any previous transferor, though they must give notice of the breach within 30 days. When a party presents an unaccepted draft to a drawee, the holder guarantees the warrantor is entitled to enforce the instrument has not been altered, and the warrantor has no knowledge that the drawee's signature on the draft is unauthorized. These presentment warranties are implied promises as to the title and credibility of an instrument made by a payer or acceptor upon the presentment of the instrument for payment. usually to the bank if it's a check. These warranties only apply to drawees acting in good faith. That's the bank. Only the first warranty above is made for instruments that are not unaccepted drafts. A check or other draft does not of itself operate as an assignment of funds in the hands of the drawee available for its payment, and the drawee is not liable on the instrument until the drawer actually accepts it. Next, we'll discuss avoiding liability for negotiable instruments. If a plaintiff sues to enforce a negotiable instrument, a defendant can try to avoid liability by either claiming a defense to enforcement or arguing that the liability has been discharged, terminated. You can raise a defense to liability. There are two categories of defenses, real and personal. Go back to Exhibit 18-3 as a reminder of what they are. Real defenses are not affected by holder in due course status and apply to all holders, even holders in due course. They are infancy, below the age of legal consent, duress, lack of legal capacity, illegality of the transaction, fraud in the factum or execution, which is basically not knowing the instrument being signed as negotiable, discharge through bankruptcy. If your debt is discharged through bankruptcy, you're no longer personally liable for the debt. Then there's forgery and material alteration. I do want to give you a note about material alteration. If the alteration is fraudulent, then the innocent party is discharged from the obligation. If the alteration is not fraudulent, then the instrument will be enforced under its original terms. And there may be instances when an instrument is altered materially but not fraudulently. For example, there could be a copying error or a typographical error. Now, personal defenses are not enforceable against a holder in due course. They are only enforceable against a regular holder. Now, these personal defenses are based in contract law. Breach of contract or warranty, lack or failure of consideration, fraud in the inducement, illegality, and mental capacity. These personal defenses come from the UCC in Article 3. Defense of non-issuance, conditional issuance, or special purpose issuance. Defense of modification or nullification of obligation by separate agreement. Defense of non-delivery of the instrument. Defense of unauthorized, non-fraudulent completion of an instrument. Exhibit 18-5 gives a nice summary of the defenses available, and if you're familiar with this chart, you should do well on the quiz. The last topic we are going to discuss today is discharge of liability on instruments. That means terminating liability on the instrument. Just as in contracts, when a party's liability on a negotiable instrument is terminated, the liability is said to be discharged under the law. That's a term of art. I tested on that before, so you should remember it. Discharge through payment or tender of payment is just paying off the amount due. That is the most common termination of liability. Now, tender of full payment that the holder refuses to accept will also operate as a discharge to any endorsers. The debtor will still owe the amount due, but will not have to pay any interest due to the improper refusal to accept payment. Now, discharge by cancellation or renunciation. This is forgiving the debt or agreeing in writing not to enforce the debt. Then there's discharge by reacquisition. This is buying back the instrument, and it releases all the intermediate endorsers or holders. Then there's discharge by impairment of recourse. If a holder impairs an endorser's right or ability to seek recourse from other parties, the endorser is not liable on the debt. The last is discharge by impairment of collateral. If the holder of the collateral impairs or reduces its value, the party to the instrument is discharged to the extent of the damage to the collateral. This is the end of Chapter 18.